The next step up in our scheme of support for vulnerable children in this country is a step called Child in Need Support. And Child in Need support comes from Section 17 of the Children Act 1989. But there are also important bits of law around support to be provided to children in need, contained in Part 3 of the Children Act 1989 more generally, in the Care Planning, Placement and Case Review Regulations of 2010, in the statutory guidance which includes the Working Together to Safeguard Children guidance, which was last updated in July 2018, and in the Children Act 1989 Guidance and Regulations, Volume 2, which is called Care Planning, Placement and Case Review Regulations. The legal definition of a child in need is a child under 18 who is unlikely to achieve or maintain a reasonable standard of health or development without the provision of services from social services, or a child whose health or development is likely to be significantly impaired or further impaired without the provision of services, or a child who is disabled. Children in need have a number of really important rights. Firstly, they have a right to have a lawful assessment of their needs. And that right comes from case law. So it comes from judges having decided in previous cases about the duties that local authorities, social services have towards vulnerable children, that it's absolutely fundamental that children have an entitlement to be assessed properly. Children in need have a right to have their wishes and feelings taken into account when decisions are taken about what kind of services should be provided to them. They have a right to have a decision about whether services or support should be provided at all. That sounds obvious, but another problem that we see in practice is that sometimes a local authority social services will assess a child to determine if that child is in need, but will never actually make a decision about whether that child's in need and what support should be provided. But the legal framework is quite clear that a child who may be a child in need under Section 17 of the Children Act should have a decision setting out whether they require support, and if so, what support they require. If they do require support, a child in need has a right to have a child in need plan, a care plan, which sets out what support is going to be provided, by whom that support will be provided, and for what purpose, i.e. how does support that's been identified, how does that meet the particular needs that a young person has been found to have in an assessment of their needs. So if we break that down a little bit further and start with the assessment of a child in need, a key principle of a child in need assessment is that it is the gateway to support from social services. So whereas we've seen early help can be provided by relevant partners of a local authority, so can include services that are universal as well as targeted programmes, and that assessment is done by a lead professional who isn't usually a social worker. A Section 17 assessment is done by social services because it is the first gateway through to support that has to be provided by social services. But we are still not in the child protection framework. So a child in need assessment is not looking at whether your child needs to be protected from a child protection purpose. a child in need assessment is looking at whether your child is a child whose health or development or well-being will be impaired without the provision of services. In order to be a lawful Section 17 assessment, the courts and the working together guidance provide us with some information about what a lawful assessment entails, because the Children Act itself doesn't tell us. The working together guidance tells us that in order to be a lawful Section 17 assessment, child in need assessment, an assessment should gather all relevant information to be able to fulfil its purpose being to identify, is that child in need, and if so, what services does that child require to prevent their health or well-being being impacted. The working together guidance tells us that really high quality assessments should be child-centred. They should focus on actions and outcomes for a child. They should be holistic, ensure equality of opportunity for children from vulnerable backgrounds, that they should involve the voice of the child where the child is old enough to express that voice. Obviously, where we're talking about babies, that provision is of sort of less significance. That the child in need assessment should involve their families, that they should identify any risks to the child or to the family, functioning family stability. That assessments should be multidisciplinary, and that they should be a continuing process. The working together guidance also tells us that a Section 17 assessment should lead to action and services if it's identified that a child is in fact a child in need. Those assessments should be transparent, and they should also be open to challenge. So if there are things within the assessment that the child or that the family of the child disagree with, they should be able to challenge those statements or those things. Sometimes information in assessments is inaccurate, or it's been worded in such a way that it might be misleading, or it might suggest something which reflects only a sort of half a situation, or doesn't properly explain the reasons behind a particular set of circumstances. So assessments must be able to be challenged by the individuals who they relate to. Section 17 assessments have to comply with what the working together guidance tells us, unless the local authority social services have very good reason to depart from that guidance. So just by way of background, the working together guidance is what we call statutory guidance. And statutory guidance is very important because although the word guidance might suggest that it's just sort of best practice or it's something to be mindful of, actually the term statutory guidance gives it a much greater weight in law. It means that it's something that the local authority must comply with legally unless they can provide very good reasons to depart from an aspect of that guidance or from that guidance entirely. If the local authority do seek to depart from what the working together guidance tells us about what assessments should include or how they should be done, the local authority should be able to provide those very good reasons and justify why they're departing from the usual expectations that we would have of a good assessment. Section 17 assessments must be done fairly, and when we look later at general public law principles, I'll explain in a bit more detail what fairly means, but for now, suffice it to say that they must be done in a fair way. The working together guidance also tells us that it should be a social worker who leads on a Section 17 assessment. So we've already said that an assessment should be done by social services, but obviously there are different levels of qualification of individuals working within social services. The Working Together guidance tells us that really it should be a social worker who's doing a Section 17 assessment, or at least who is leading on that, so who is considering the information, analysing information gathered, making a decision about needs at the end of that process. The Working Together guidance tells us that an assessment should be holistic. Well, what does that mean? Well, in the Working Together guidance, and I'd encourage you all to download a copy of that guidance from the internet. It's government produced guidance. There is a triangle which sets out all of the considerations to be taken into account when assessing the needs of a child in need. This is called the assessment triangle, and what it does is it shows that there are different kinds of needs that a child might have and different considerations which affect those needs, so different things that affect a family which might create those needs. The Working Together guidance tells us that the important information to be gathered is all of those considerations on that triangle, and that there's no hierarchy between these. So it's not acceptable for a local authority to focus entirely on parenting capacity, for example, and to ignore that the family might have very difficult financial or social situations, that the parents might lack any kind of social network or support. Actually, that's a very important consideration that has to be balanced against others. The idea is that a social worker gathers all of that information, so looks at all of those considerations, and then analyses whether a child is a child in need, and makes a decision at the end of that assessment about whether a child is in need. If the decision is taken that a child is in need, the local authority social services then needs to determine what support should be provided to meet those needs to improve the child's outcomes. The process for getting an assessment under Section 17 of the Children Act, so an assessment for child in need support, is usually as follows. So ordinarily a referral would be made to the local authority social services. So this might be made by an advocacy organisation or by relevant partners such as the police, a school, health professionals, etc. Within one working day of receiving that referral, social services need to acknowledge to the referrer that they've had the referral and make a decision about whether a Section 17 assessment is required. If they decide that a Section 17 assessment is required, the local authority social services have up to 45 working days to complete that assessment. And that timescale is given by the Working Together guidance. So that means, as statutory guidance, that if the local authority are taking longer than that 45 working days to complete an assessment of a child in need, they should be able to provide reasons as to why they're departing from that guidance, why they're taking longer than that guidance gives them to do an assessment, and they need to be able to record those reasons. If, following an assessment, the local authority determines that support is required, they need to create what we call a plan of action, or a child in need plan, that sets out what support is going to be provided to that child, by whom that support will be provided and for what purpose, i.e. what need is a particular bit of support intended to address. It's important to understand that support can be accessed before the assessment process is actually completed. So the local authority social services have legally up to 45 working days to complete that assessment, but that doesn't mean that they shouldn't provide support earlier if it's absolutely obvious that there is a need that requires instant support that needs to be addressed sooner than that. So the Working Together guidance tells us that the local authority must not wait until an assessment conclusion before commissioning services to support a child and their family if that support is needed. In addition to that general guidance that we have from Working Together guidance and from the courts who say that assessments should be fair, for example, local authorities also have their own protocols about how assessments will be done, and the local authority is under a duty to publish their protocol. So you should be able to obtain a copy of that from the local authority's website, or you can ask for a copy of that from your local authority social services department. The protocol has to comply with the Working Together guidance. So again, just because the sort of protocol a threshold exists, it must still be consistent with the law itself, the law being Section 17 of the Children Act and the Working Together guidance. And the protocol gives us a bit more detail about how the local authority is going to translate those legal provisions into day-to-day practice in terms of conducting assessments. So it should, for example, set out how professionals from different bodies can make contributions to an assessment. So it might be that a teacher, a support worker, an advocate has some important observations or information which they want to feed into a child in need assessment, and the protocol should make clear how that can happen. The protocol should also tell us how assessments can be informed by other specialist assessments. So it might be, for example, that a mental health assessment of a child or another kind of health assessment is necessary to gather information which will sort of add important information into the child in need assessment, or it will inform the decisions to be made following on from that assessment. And the protocol should make clear how any other kinds of assessments will be considered in conjunction with or as part of the child in need assessment. The protocol should also set out how any points of review will be managed. And what we mean by this is any points that are disputed. I said earlier that a child or family has the right to challenge assessments, that they should be open, that they should be transparent, and that if something isn't correct or isn't worded in a way which properly reflects the situation, that family should be able to say so. Well, the protocol that the local authority publish tells us how local authorities are going to deal with those points when they arise, and how they're going to ensure that those points are fed into the assessment process so that the assessment is fair and comprehensive and accurate. The final thing the protocol needs to do, or the final thing that sort of I'm going to mention, is that the protocol needs to tell us how the local authority is going to make sure that a child or their family actually understands the type of help being offered and what their responsibilities are in relation to that help. Sometimes a local authority social services will conclude that a child is in need and will identify support that could meet those needs, but that support might be conditional to the child or their family taking certain steps or doing certain things. Well, the protocol that the local authority publish should make clear how the local authority is going to ensure that they explain to a child and their family what support needs there are, what support they intend to put in place to meet those needs, and if there are any conditions or responsibilities that the family need to undertake in order to access that support. The protocol tells us that social services need to make clear what those are to the child or their family. So we've been through the assessment process, and we now need to think about what help is actually going to be available at the end of that process. And following a child in need assessment, Section 17 assessment, there are two things the local authority can do if they think a child has needs. So they can provide services under Section 17 of the Children Act 1989, or they can provide services under Section 20 of the Children Act 1989. Section 17 of the Children Act states that services that can be provided can be anything, and that can include accommodation to a child in need and their family. Section 20 of the Children Act 1989 states that support for children in need can be provided by the local authority accommodating them, but in a different way, accommodating a child in such a way that the child becomes looked after. And this triggers a number of separate responsibilities that the local authority will then have towards the child, which we will look at later when we move up the rungs of our scheme, up the steps of our scheme, to look at looked after children in more detail. So Section 17 services are anything. Well, what does that mean? Well, it means exactly that. It means that there's absolutely no restriction on what local authority social services can do to support a child who they consider to be in need, if that support would meet the needs of the child. That can include the local authority providing accommodation to the child with their parents, with their family. It can include the local authority giving cash to the family if that would meet the needs of the child. It can include the local authority providing services, not just to the child but also to their family, which might be access to particular programmes or particular kinds of support that the family wouldn't be able to access other than with the local authority commissioning that support. Any support that is identified, because it can be so broad under Section 17, needs to be set out in detail in the child in need plan, the care plan produced at the end of the assessment. That Section 20 duty that local authorities have to provide accommodation is a very, very specific bit of law, a very specific duty. And it's a duty that local authorities have to accommodate a child who they consider to be in need, where that child is found to have no one with parental responsibility for them, i.e. they are an orphan or an unaccompanied asylum-seeking child, for example, or it's a child who's lost or abandoned, or it's a child who, where the person caring for that child is prevented from whatever reason from providing suitable accommodation and care for them. Now that's really broad. Prevented from for whatever reason can include where the family simply don't have the ability to accommodate a child adequately because of that child's particular needs, i.e. because of their disability, or where a family's resources mean that they can't put a roof over the head of that child. Potentially that could be a child who could be accommodated under Section 20. Local authorities cannot, however, accommodate a child under Section 20 of the Children Act if there is a parent who is willing and able to provide accommodation for that child and that parent objects. In other words, Section 20 support for a child in need can only be provided if a parent consents to that support being provided. This is why Section 20 accommodation is sometimes called voluntary care, because parents are giving their permission, their consent, they're volunteering for their child to be accommodated by the local authority. Through the work of the MAP project, we've had cause to be concerned with the way local authorities often are treating Section 20 accommodation, in that they are asking parents to consent to their child becoming a looked after child, to being accommodated under Section 20, without providing information to the parent about what that actually entails, and without explaining that that means that the child becomes looked after. And as I said, there are a number of legal duties that are triggered towards looked after children, which we'll talk about in a later section. But at this stage, suffice to say that it means that the local authority becomes involved with the child in a much more intrusive and intensive way. We've also been concerned that sometimes consent isn't sought, or consent is sought in circumstances where it's really unclear that a mum actually has capacity at that stage to provide consent. Providing consent means that you understand what you're consenting to. So, for example, straight after giving birth, while still under the influence of pain relief, or when you're very tired, if you've had a long labour, that might not be the best time for a local authority to be presenting you with a piece of paper asking you to consent to your child being accommodated by them as a looked after child. So it's really important when you think about Section 20 accommodation, and about whether parents have volunteered, have agreed to their child being accommodated in that way by the local authority, that we think about whether they have actually provided agreement or valid consent to that situation arising. Particularly as, of course, local authorities can accommodate children without accommodating them under Section 20, and in that way, if they accommodate the family together under Section 17 of the Children Act as a child in need. In the same way as with early help, it's possible to find out what local authorities provide as child in need services in a particular area, because local authorities have to publish information about what services they have for child in need support. Interestingly, for children in need, they have to do more than that. In addition to publishing what services are actually available, local authorities have to take reasonable steps to ensure that those who might benefit from child in need support receive information that's relevant to them. This comes from Schedule 2 of the Children Act 1989. I must say that in practice, I'm not aware of local authorities going out of their way to make a young mum, for example, aware of all of these services which could potentially be accessed by her family to support her child as a child in need, and could be provided to her together with her child. But nevertheless, that legal duty is there. So if there are services that the local authority thinks might make a real difference to a young mum and her child, and those services are child in need services and are paid for and commissioned by the local authority in that way, then the local authority should be making families aware of those. Next, we'll go on to look at support for looked after children and children in care. So we'll move up the steps of support to the level where child protection issues arise.